Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Happy New Year. I'd like to welcome you to this morning's webinar where we're going to be talking about basics of the Sunshine Act, or what's otherwise known as Pennsylvania's open meeting law. Let's talk about a couple preliminaries before we dive into the subject. First offhand, if you've never attended one of these webinars before, it's essentially a PowerPoint presentation with me talking in the background. All of our PowerPoints, including this one, are available for use on our website. You can go to the training tab, scroll down. You'll find the PowerPoints that we use for all of our trainings, and they're available for your use to download and use as you see fit. Perhaps there was a colleague who couldn't attend this morning. Maybe you have some localized training, or maybe you just like to have it available for your own future reference. We consider them public records, so you're more than welcome to download them as you see fit. Also, this session is being recorded. What we do is upload the recordings to our YouTube channel, and then the administrative staff creates a link to our website so that you can find the most recent recordings of all the webinar topics on the website. So barring any technical difficulties, this should be posted within a couple days. Again, for your use as you see fit. If you have a friend or colleague who couldn't make it this morning, you can show them the way to the recording. And same way, you can come back and refer to it as you see fit as well. You are able to submit questions, and we encourage that during the session. Use the chat feature, type in the question, and I will do my best to answer live as we're going through the various topics. I have two favors to ask you, though. First is, we're talking about the Sunshine Act, so let's stay on topic and keep our questions pertinent. Second, and probably more important, is try to be as short and concise as you can be. Every now and then someone will type in several paragraphs, and it's just awkward for me to sit here and read through that while everyone else is waiting patiently with the dead air time. If it appears that you have something unusually complex or unique to your particular situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll come back to it, or we'll take the conversation offline. On the screen now is contact information for the Office of Open Records, our website URL, the office phone number. We have administrative staff who are very well versed in both the Right to Know law and the Sunshine Act. They will do their best to answer your questions, and if they can't, if you stump them, we'll escalate your question to one of the senior staff, and typically they're able to get back to you within 24 hours, and we'll try and get you steered in the right direction. Just for your own reference, we can't write requests for you. We can't respond to requests for you. We can't discuss active appeals, and we can't provide legal advice. But what we can do is take a look at the factual circumstances, probably find something that we've ruled on that's very similar to what you're presenting, and get you steered in the right direction so that you know how the Office of Open Records would have responded given a similar set of circumstances that's on record. Okay, I think that takes care of all the preliminaries, so let's dive into the topic. And the first thing I want to do is talk about why the Sunshine Act is important. Okay, why do we have this webinar? Why do we have this law? And what I want to do is read right from what is basically the preamble of the law itself. So bear with me here while I run through this. It's the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formulation, and decision-making of agencies, vital to the enhancement and proper functioning of the democratic process, and that secrecy in public affairs undermines the faith in the public in government and the public's effectiveness in fulfilling its role in a democratic society. Okay, a very altruistic statement, but yet it is so accurate in why this law is important. I've had the opportunity to travel to different countries, and I have to tell you, when you're when you're driving down the road and a pickup truck passes you with a bunch of men all dressed in black, their heads covered, and they're carrying machine guns, you wonder about whether would have the opportunity to stand up in a public meeting and make a statement. I don't think so. Okay, this is unique to democracies. And even then, some of these countries that I've been to claim to be democracies, and it's not my place to say whether they are or not, but the opportunity for a citizen to stand up, point a finger at a public official, and tell them what you think is unique to only a few countries. And even in the United States, Pennsylvania has one of the stronger open meetings law where we have the opportunity to do that. And that's what this preamble talks about. It's the right of the public, you and me, to stand up in a meeting, tell folks what we think, and witness the processes, the thoughts, the discussion that takes place in formulating the laws that we all are charged with abiding by. So I think you can tell I take this very personally, and I think it's an important topic that we as citizens have a right to know, not only how our government works, but to witness it actually working live, as it's occurring. Okay. So folks will oftentimes email us or call into the office, and it'll be something like, if it's a citizen, they'll want to know, hey, did my township break the law? Did they violate the Sunshine Act? Or, the township will call in and they'll ask, are we in compliance if we do this? So when we get queries like that, I like to think of the Sunshine Act as a three-legged stool. And there are three major points that we look for. Now, granted, there are other aspects of the Sunshine Act that, require compliance, but these are the three big ones. First is that any public meeting, any public gathering, well, any public meeting for our sense, needs to be needs to have advance notice with instructions on how to attend. Okay, and when we say how to attend, it's not just where the meeting is, but if the meeting has an online component, okay, how do you go about signing on? How do you get into the social media platform that's being used to broadcast the meeting? Then we have a right to observe those deliberations. Now, the word deliberations actually has a specific definition, and we'll talk about that. But the public has a right to witness the discussions that lead to the decisions that our public officials are going to make on our behalf. And then finally, does the public have the opportunity to comment on those deliberations and potential decisions prior to the decisions actually being made, okay, prior to the vote taking place? Now, I talk about specific definitions, and I think that's an important thing to cover right now. Whenever you're trying to understand a law, okay, you read through it, and there may be some language that's written in legalese. It's hard to understand. There may be some language that's vague. You're not quite sure what's meant here. And you may encounter provisions that appear to be in conflict with each other. Okay, now which takes precedent? Okay, how do we understand this? I always recommend that you go to the definitions section of a law, and that oftentimes will provide clarity. It will shed light on the meaning of specific words that are used, in some cases not used, throughout the text of the law. Okay, it's a little extra mental exercise here, but it can really help you understand what the intent of the law is and what the intent of specific provisions are when they may not always be written as clearly as we would like. Take a look at the definition section, and the Sunshine Act is no exception here. And we're going to be referring to that in a number of cases. Okay, so let's move on. First thing we want to do is discuss who is covered by the Sunshine Act. Well, it's any state or local government body and all committees. Okay, state or local government body. State, we're talking about, departments, boards, commissions, authorities that are created by statute and the like. And then local government, it's pretty much the same. Cities, boroughs, townships, authorities, school districts. As an extension of school districts, you would have public charter schools, all considered subject to the Sunshine Act. But then we come into this term "and all committees," okay, specifically taken out of the Sunshine Act. But this question comes up a lot. Is our committee subject to the provisions of the Sunshine Act? There's a lot of misunderstanding about this, so let's try and shed some light. First, I'm going to go through what the law itself says. And this is one of those definitions, okay? A committee, the first thing we'd want to know is it performing an essential government function? Okay, that's a somewhat subjective phrase, but let's parse this apart with an example. Let's say that we live in a township where the local girls softball team has won the state championship. Okay, it's quite an accomplishment for them. And we want to recognize this accomplishment and celebrate. And so our township supervisors appoint an ad hoc committee where they're going to organize a parade, and then we're all going to meet at the township park and have, a cookout or, some sort of celebration and recognition of this significant accomplishment. All right. Is it an essential government function? Well, probably not. Okay. So you could argue that this ad hoc committee that's been formed is not subject to the Sunshine Act because you're not going to find anything in statute or law that requires a parade and recognition ceremony for winning the state title with the softball team. But let's change it up a little bit. Let's say that it's a standing committee that is tasked with annually reviewing all local ordinances to make sure that the language is appropriate, that the ordinance itself is written clearly, that it is not in conflict with any federal or state statutes, and it just makes sense that we would still have this and written in the way that it currently is. Okay, now that, I think you could argue that it is an essential government function, that our laws be understandable and up to date. Therefore, that committee more than likely would be performing an essential government function, and it would be subject to the provisions of the Sunshine Act. Okay, now we move to the next component, and these build upon one another. Okay, does the committee exercise authority to take official action? Now you're thinking, why wouldn't they? Why would you have a committee that doesn't have authority to take official action? Well, occasionally, sometimes committees are appointed just to gather information. Okay, go out and research this topic so that you can come back to us and provide us with that information. Now, I talk about definitions. Okay, you go into the definition of official action because maybe you're not quite sure what that means. And sure enough, within the definition section of the Sunshine Act, you're going to find a definition of official action. Included in that definition is the term making recommendations. So that if your committee goes out and does something or, has discussions or whatever, takes, deliberation, and then comes back to the elected board and makes a recommendation, well, that committee is exercising authority and taking official action just by making a recommendation. Okay, so if it deliberates, if it meets, if it gathers, and then comes back to the board and makes a recommendation, that recommendation constitutes official action. Thus, the gathering of that committee would be subject to the provisions of the Sunshine Act. Now, let me address a common misunderstanding here. And that would be that in order for a committee to be subject to the Sunshine Act, there needs to be a quorum of elected officials. And that is simply not accurate. You're not going to find that anywhere in the Sunshine Act. You can have a committee that has no elected officials on it. And if it is performing an essential government function and exercising authority to take official action, it could be subject to the Sunshine Act with, like I said, no public officials involved at all. What's needed would be a quorum of committee members, because you need a quorum to conduct any form of business, okay? But you do not need to have public officials on a committee in order for it to be subject to the Sunshine Act, okay? Just so we have that made clear. All right, moving on. Now I want to talk about case law. With the Sunshine Act, there's not a lot of case law for a number of reasons. But oftentimes, case law is used, again, to help provide clarity on how a law is applied, because it includes how the courts have weighed in and determined how specific provisions of a law should be applied when there is disagreement. Okay, so the courts write a ruling, and we use that text to understand how a law should be applied in a given set of circumstances. And in this case, we're going to deal with committees, and the case citation is called Ristow versus Casey. Casey, Governor Robert Casey, from several decades ago. And the question was, this committee that was formed, is it subject to the Sunshine Act? And in this case, the Pennsylvania Commonwealth Court ruled, well, in their ruling, they provided significant discussion, and it dealt with whether or not a committee or what conditions must exist for a committee to be subject to the Sunshine Act. So it goes into a little greater detail than the language in the law itself. And like I said, I think it provides a little bit more clarity. So let's run through the conditions that the Commonwealth Court set up for Ristow. First offhand, and this goes back to what we were just talking about, does the committee have decision-making authority? And again, you might be thinking, well, why wouldn't a committee have decision-making authority? Well, in some cases, they're just appointed to go out and gather information. You know, we don't want any recommendations. We don't want any decisions. We just want you to come back with information for us. Okay, in that case, they would not be subject to the Sunshine Act. Then you have other instances where, you know, the reality of the situation is that when a board is faced with an awkward topic, an awkward potential decision, one of the best ways to make something go away is to assign it to a committee. And hopefully you'll never hear from that committee again. You know, people just forget, and the committee dies on the vine because of lack of activity or lack of a clear mission. Okay, so the task assigned to the committee is, we don't really want you to do anything, but we want you to go take a look at this. Okay, you don't necessarily have to get back to us. Just go, you know, we'll assign it to a committee. That makes it look like we're doing something when in fact we're not. Okay, it's unfortunate that this exists, but sometimes it's the most expedient way to deal with an issue, by not dealing with it. Okay, then we need to answer the question, and like I said, with the language in the law, this kind of builds on each point. Are the members of the committee appointed by the board, and are they authorized to act on its behalf? Okay, well, we do encounter committees where the membership is not appointed by the elected officials within that jurisdiction. Um, I'll give you an example. Across Pennsylvania, there's a great variety in the governance used for public libraries. For the most part, they're determined by the state statutes for governing libraries, but some of these libraries predated those statutes. And there may be a public library with a very, if any, nexus between the jurisdiction, the elected officials, and the running of the library itself. Okay, it's for the most part completely independent. And if there is a vacancy on the library board, this subcommittee, if you will, the appointments are not made by the elected officials. Maybe they were made originally when the board was formed, but if there's a vacancy, rather than the public officials approving the vacancy, the board itself, the committee, is responsible for going out and finding a volunteer to serve on the public library board. Okay, in that instance, the members are not appointed by the elected officials, by the elected board. Thus, chances are they would not rise to the level of satisfaction for this particular criterion. Okay, so thus they would not be subject to the provisions of the Sunshine Act. Okay, and obviously they would not be authorized to act on its behalf because the members aren't even appointed by the elected officials. And like I said, that nexus between what the public library board does and what the elected officials do is very weak, if it exists at all. Okay. Then there's the one that I consider the most important. This is the one that I really take a close look at when this question comes up. Are the recommendations pursuant to statute, ordinance, or regulatory authority whereby the making or enactment of laws, policies, or regulation is the end result? Okay, let's translate this into English. The board takes official action, or I'm sorry, the committee takes official action by making recommendations back to the elected officials board. All right. But are those recommendations pursuant to statute? Can we find some basis in law? Okay. Remember my example about the softball team. Okay. They come back to the elected officials saying, we want to have a parade. We want to invite these high school bands. We want to invite these fire companies. We want to gather at the local township park, and we want to have barbecued chicken. Okay, so it's going to cost X number of dollars. This is our recommendation. Okay, now they're making a recommendation. So you think, aha, that's official action. But if the recommendations can't be grounded in any sort of statute or local ordinance or any sort of regulatory authority, then that kind of wipes it out. Okay. If you can't point to a law and say, this is what the recommendation, these are the parameters that the recommendation is being made within, then that removes it from jurisdiction under the Sunshine Act. Okay. So we look at the girls softball team. You're not going to find any ordinance, any statute that governs how we celebrate winning the state championship. Thus, you cannot make the argument that the Sunshine Act applies. But if we go to the other example where, annually legal review, all ordinances, language is germane, they need to make sense, they need to apply, et cetera, et cetera. Yeah, you can find that. Okay. So there you can arrive at a different conclusion that the gatherings of that committee, the second example, would be subject to Sunshine Act. Okay. Now, all that being said, going through the act itself and the language of the Commonwealth Court with Ristow, maybe you're still shaking your head saying, I don't know. Okay, well, here's my recommendation. If you're unsure, lean towards transparency. Open up your gatherings to the public so that they can participate. Now, that is inconvenient because of all the hoops that you have to jump through and so forth. But from a very pragmatic perspective, the alternative is that if you decide to forego opening up your gathering, you risk the potential of a complaint. And then you have to pass what I call the straight face test, where potentially you could be forced to stand before a judge and explain to them, why didn't you open up your meeting? And quite frankly, if the judge doesn't agree with your reasoning, you could be subject to sanctions. And that would be far more inconvenient than simply opening up your meeting and allowing the public to attend. Okay, and then there's the final point is that, this is the Office of Open Records. We're responsible for government transparency in Pennsylvania. So of course we're going to say, open up your meetings, lean towards transparency, because quite frankly, it's the right thing to do. Okay, but going back from a very practical perspective, by opening up your meetings, you might be saving yourselves from some significant headaches and some significant pain to your wallet. Okay, moving on. Let's answer the question, is it a meeting? Okay. Sometimes people will call the office and so they say, I saw 3 of our township supervisors having breakfast the other morning at the local restaurant. Isn't that illegal? Well, no, not necessarily. It depends on what they were talking about. Maybe they were just talking about the weather, their kids, the girls' softball team, who knows? But couple things that need to be addressed, couple questions need to be answered before you can make any sort of conclusions. First offhand, is there a quorum? Okay, elected officials or the committee or whatever. Let's talk about elected officials specifically. Okay, well, you need a quorum to conduct any sort of official business. Now, what about phoning in? All right. Second-class townships, well, let me say who can't phone in, okay? First-class townships, counties, and boroughs, okay? A quorum must be physically present, okay? And this is not, you're not going to find this in the Sunshine Act. This is based on their codes, okay? The state codes that govern boroughs and first-class townships, okay? A quorum needs to be physically present in order to conduct official business. Anyone in addition to the quorum can then phone in, and maybe it's an online meeting, okay? They can use Zoom or Teams or whatever. But the connection must be direct, meaning that whoever is phoning in can hear everyone else at the meeting, and everyone at the meeting can hear the person phoning in. You can't have someone sitting in the meeting with a cell phone up to their ear relaying back and forth, okay? The communication must be direct. Now, in the case of like a second-class township, you can have a quorum with a person phoning in, okay, as long as you meet that quorum. And again, the same conditions apply. But for boroughs, first-class townships, you need that physical quorum present. Then you need to answer the question, is there deliberation taking place? Now, definitions. Deliberation is any discussion that could lead to a decision. All right. If you're talking about the weather, oh, and yeah, I should clarify. It needs to be about the business of the jurisdiction. Okay, so if it's a township, they need to be talking about, they need to be deliberating about township business. If they're talking about, what the heck's going on with the Eagles lately, that's not township business. Okay, they can have that discussion. Okay, but deliberation is discussion about any business of the jurisdiction that could ultimately lead to a decision. Okay. So if they're talking about paving streets, if they're talking about buying some new equipment, any personnel issues or the like, they could find themselves, maybe getting into some trouble there, that you need to be careful about what you're talking about to make sure you're not deliberating about township, borough, or city business or school district business. Okay. Then, is there any decision making? Decision making is a vote, okay? And that can be informal, just, hey, Fred, what do you think? Mary, what's your opinion on this? How would you vote? Okay. And that's decision making, okay? You can't do that outside of the public eye. Okay. So, yes, you can gather. You just need to be careful about what it is you talk about, what it is you do, um, because if you're deliberating or if you're making any decisions, you could be in violation of the act. Then finally, I want to caution you about email meetings. Okay. This time of year, new boards are being seated. Maybe the person elected as chair comes from a business background and they get the bright idea. Well, at work, a lot of this stuff, we don't need meetings. We can just handle this with an email. Okay. And everybody weigh in, tell us what you think, and we'll move from there. Unfortunately, or I probably shouldn't say unfortunately, but the reality of the situation is that you very well could be violating the Sunshine Act because you are deliberating using email, and you can't do that, okay, when it comes to policy level decisions. Now, for administrative level decisions, yes, you can deliberate using email outside of the public eye. What's the difference? Okay, well, let's say that the board in a public meeting completely legally votes to spend $3 million on street paving for the next fiscal cycle. Okay, that's the vote. Okay, it's done all above board. The vote is approved. It becomes a matter of public record. But then the question comes up, well, what streets should we pave? Okay, that is more of an administrative matter because the decision has already been made. Okay, now we need to work out the details. Okay, so that sort of thing can be addressed using email among the members of the board. Okay, administrative level decisions. But be careful because, again, this is subjective. There may be some people that think the decisions on what streets need to be paved is more policy in nature rather than administrative in nature. Use your best judgment there. I'm going to talk about recordings in a little bit, Mike, so sit tight. So you need to, use your judgment as to what's administrative versus what's policy. But the point being, if it is administrative in nature, that can be dealt with outside of the public eye because the policy level decision has already been made in a public setting. Okay, just so we clearly understand that. Okay, what is not a meeting? Well, I just got done talking about administrative action versus agency business, so I think we've pretty well have that covered. Work sessions, conferences, and retreats. Okay, I'm going to talk specifically about work sessions because the best example we have here are school districts, where quite often a school district will have a monthly business meeting where the public is invited, there's deliberation, there's votes taking place, and so forth. But then they will also have work sessions. And a work session is where the communication is primarily one way. The board will gather, and then like the superintendent, the assistant superintendent, principals, deputies, assistant principals, and the like, all make presentations on matters that the board has an interest in. Maybe they're educating themselves so that they can make informed decisions when it does come time to make a vote. So the superintendent will stand up and give an update on a particular project. Now, an individual board member may have a question for the superintendent, okay, and they can have that discussion back and forth. What cannot occur is discussion on the merits among the board members themselves, because that is deliberation per that definition that we talked about. Okay, so the board cannot deliberate during a work session. Now, a couple things that we need to clarify here. This has been in the news recently, and it's been a problem that we've had for a couple years where, and it's not just school districts, but a government entity will form what's called a committee of the whole. Okay, it's, semantics. Basically, the board is meeting and they're having discussions and they're making decisions, but they're saying, well, this is just a committee, okay? And we're just having all the committees gather at the same time to meet with the board so that we can have, committee discussions, committee level discussions. You can call it whatever you like. If you're deliberating and you're making decisions, that needs to occur in a public setting. The other thing that's happening, and not as frequently, are boards are complying with all the provisions of the Sunshine Act by advertising, by allowing the public to be present, even allowing public comment, but they're still calling it a work session. Now, there's no case law that governs this, but I have a lot of heartburn with that because when I hear work session, there is the expectation that no decision is going to take place. So let's just, use an example, and this has happened, where there is some big issue that a township or a borough is going to be dealing with on the horizon. Maybe it's some zoning issues. Maybe it's voting to approve one of those big warehouses coming in, okay? And everybody knows that it's going to happen sooner or later. But the board ends up advertising a work session. And then because they have complied with all the facets of the Sunshine Act, they vote on the issue at the work session. Okay, now they, shrug their shoulders and say, hey, we did everything that the Sunshine Act tells us to do, but you ended up calling it a work session, not a public meeting. Okay, I think that's, playing fast and loose. And again, are you willing to stand up in front of a judge and explain your reasoning? Why did you take a vote when you called it a work session? Okay. And, if you can do it with a straight face, maybe, that's up to you. But I would caution you against that. Okay. The more you try to play fast and loose with the law, the Sunshine Act in this case, the greater the chances are you're going to get caught. And everyone always does. And sooner or later, the truth comes out. And, it's up to you as to whether you want to roll the dice and take that gamble. But if I were in your shoes, I would not. All right. So next question we have to answer. Is there deliberation? Well, if it's not a meeting, there's no deliberation. Like we talked about, the guys meeting for breakfast. If all they're talking about is the weather, their kids, the softball team, then you don't have to worry about it. Okay, is there any decision making, whether it be official or unofficial? Is there any sort of polling as to what's going on? If there is, that's a problem. If not, then you don't have anything to worry about. Okay, but you can have gatherings of public officials and even a quorum of public officials that if there's no deliberation, if there's no decision making, then it's not considered a public meeting, so they're allowed to do that. Okay, moving on. Let's talk about public notice. All right, and this is fairly distinct or fairly succinct in the law. So let's just run through it quick. Many of you, first Tuesday of the new year, last night, you would have met for your organizational meetings. Well, 3 days prior, at minimum of 3 days prior to the first regular meeting of the year, there needs to be advance notice to the public that said meeting is going to occur. And it needs to be a legal notice in a paid newspaper of general circulation. That notice would also include all of the dates for the regularly scheduled meetings for the remainder of the year. So if you're meeting the first Tuesday of every month, you would have that date in your legal notice. Okay, those 12 dates. It needs to be a paid newspaper of general circulation, okay? So that would mean that a newspaper article, what they typically call a puff piece, wouldn't count. Okay, it needs to be one of those legal notices that you pay for. Having it on your website, while that is a good idea, and I would recommend using social media to advertise your meetings. It doesn't satisfy the language in the law itself, okay? It needs to be also include that paid newspaper of general circulation. And those free sales circulars that fill up our mailboxes 2 or 3 times a week, they don't count either. Paid newspaper of general circulation. Now, I realize this is a problem for many municipalities nowadays because of structural changes that we're seeing in the news media industry. Okay, but until the law itself is changed, this is what you need to adhere to. If it is a problem for you, I would recommend contacting your state legislators, letting them know that the law needs to be revised in some way to accommodate this. But until that change actually takes place, this is what we need to adhere to. And then the meeting notices also need to be posted at the meeting site. Okay, so if it's typically held in the township at the township building, in the council chambers or whatever, the supervisor's room, then the meeting notices will be posted there so that they're readily available for the public when they come walking into the building to know when the meetings are being held. And if there is an online component to these meetings, it would include instructions on how you log into the meeting so that you can observe. Okay, we talked about regular meetings. There is also a provision to have special meetings. Okay, what's a special meeting? Well, let's say some issue comes up where you can't wait until the next month for the regular meeting. Okay, we need to make a decision beforehand. Maybe there's, some sort of federal deadline that's come up, or if we want to apply for a state grant, in order to approve the grant proposal, we got to get it in now, and we can't wait until next month. So we're going to have a special meeting. Okay, all of the same provisions apply, except now the window is reduced to 24 hours rather than 72, as long as there is a minimum of 24 hours advance notice for when it's posted. When the meeting notice is posted in the newspaper, you're okay, and you're allowed to have that special meeting. And then you can have what are known as emergency meetings. And this is where you're not required to have any notification, but it must be a bona fide emergency. Okay, you can't just make something up and say, well, let's just call it an emergency so that we can avoid the provisions of the Sunshine Act. And trust me, that has happened. And they've had to face that straight face test. Okay. So be careful about, making sure it's a bona fide emergency. And I'll give you a quick example, and it's might be very germane given the weather forecast, but you've got a small township, you've got one snowplow, and that snowplow is pretty old. It's on its last legs. The guys down at the motor pool have done everything they can to keep this plow running for the last couple years, but you know what? It just blew a gasket and gave up the ghost, and we need a new plow because we can't even get parts for this old thing anymore. And the forecast says we're going to get 12 inches of snow this weekend. We need a plow. Okay, this is an emergency. We've got to make a decision to buy a new plow. Turns out they've got one sitting on the lot, a couple townships over. Let's go buy this thing. So they convene an emergency meeting. They vote to approve the purchase of the snowplow, and now they're ready for the storm. Okay, so that is a bona fide emergency that they have acted on accordingly. The other thing that I want to mention is that within the Sunshine Act, there is no legal requirement for canceling a meeting. Let's say someone gets sick and you can't have a quorum, okay? So you cancel the scheduled meeting. Nothing in the Sunshine Act says you have to advertise that, but strongly recommend use your social media outlets to advertise the fact that you're not having the meeting, okay? Because nothing upsets the public more. If they're interested enough to come to your meetings, okay, they're engaged, okay, they care about what you're doing. So if they show up for a previously advertised meeting and the door's locked, all the lights are out, and it's just crickets outside, they're going to be upset. And I know this because they usually end up calling us. So let people know when you're canceling a meeting. Put it on your website, put it on your Facebook page, tweet it out, whatever. Okay. And you may save yourself a lot of heartburn from citizens that are going to show up at the next meeting and give you a piece of their mind. All right. Do the right thing. Let people know when you're canceling meetings. Okay. Let's talk about agendas, and I'm going to include some new information here that's the result, again, of case law. Okay, now this provision, agendas, I'm not going to say it's a new provision, but it is newer in that the Sunshine Act goes back into the 1950s with its genesis. This was approved, I think, 5 years ago, where there is a requirement now that all boards have an agenda posted prior to the actual public meeting. Okay, now all agencies must post an agenda of issues to be deliberated on or planned official action. Okay, what are we going to talk about? What are we going to vote on? Okay, at least 24 hours prior to the public meeting. That's pretty much it in a nutshell. Okay, so the question comes up, well, how detailed do these agendas need to be? The law doesn't say, and there's no case law that explains it. But I'm going to take a leap here in logic. In a little bit, we'll talk about executive sessions, and there is a case that describes how detailed the explanation for executive sessions needs to be. That case it's known as the Reading Eagle case. I'm going to take the logic from that decision, how detailed does the explanation need to be, and apply it to how detailed does the agenda need to be. Okay, now I want you to understand, I'm not providing any legal advice here, and there is no basis in case law for my logic. This is simply George's opinion, which at the end of the day doesn't carry any weight at all. And if you find yourself standing up in front of a judge and saying, well, George says, that judge may look at you like you're crazy. Okay, I just want to, backpedal here a little bit to make sure you understand why I'm saying this. But in the Reading Eagle case, it basically says you need to provide enough information so that people trust you're doing the right thing. Okay, so I would look at this from the perspective of a member of the public looking at the and that's still a little subjective, but I think you get the gist. Would a reasonable person, and yeah, reasonable in quotes, would a reasonable person understand what it is we're trying to explain on our agenda that the board expects to accomplish on this particular item? Okay. If it's pay the bills, that doesn't tell me anything. But if it's pay the bills and then I list those bills and what the amounts are, well, yeah, then I can see, is there some big ticket item that the board is sneaking in here that they're going to vote on tonight? Okay, that way I understand. All right, and same way with other issues. Okay, educate the public with the use of your agendas so that they trust you're doing the right thing. Okay. Now, granted, some people, they're never going to believe you. Okay. They're never going to trust you, but they're not reasonable per George's definition. All right. So I think you see where I'm coming from here. And it's funny, I'm waving my hands all over the place trying to explain. But I think you get the gist of what I mean when how detailed an agenda needs to be. It doesn't need to be, chapter and verse, several pages, but provide a paragraph, a short paragraph on just what the agenda item means. Okay, now the agenda needs to be posted a minimum of 24 hours prior to the public meeting. And this includes regular and special meetings, which we discussed previously. You don't need to post agendas for work sessions, conferences, or executive sessions. I'll explain what an executive session is here later. Websites, okay? The law says if you have a website, you need to have the agenda posted on the website. Now, let's say you don't have a website, but you have a Facebook page. Okay, well, then you post the agenda on your Facebook page. If you have both, the law uses the term website. Now, it also needs to be posted at the agency's business offices. So that means, City Hall, Borough Hall, the Township Building, the School District Administrative Office, then at the meeting site, if that's someplace different, okay? And then you need to have copies of the agenda available for the public at the meeting itself. So you have a stack of copies of agendas there so that I can grab one as I come into the meeting and I know what to expect. Okay. What if I want to change the agenda, okay, due to something coming up? All right. Well, this is where the case law comes in. Let me get to it. Okay, let me run through this first. Prior to 24 hours, you can make any change to the agenda that you want. Okay, it's an open book. Okay, have at it. If something new comes up and you need to add it to the agenda or take something off the agenda, you can do that. Okay, no problem. Now, once the 24-hour window has lapsed, though, you can only change the agenda for emergency or de minimis items where there is no expenditure of money. Okay, whatever we're voting on, it's not going to cost anything. And we're not going to enter into any sort of contract. Okay. Now, these two examples are not all inclusive. You can have other non-de minimis items that could come up that you would want to add to the agenda, but you cannot because they are not de minimis in nature, okay? So, but expenditure of funds and entering into a contract are two examples specifically cited in the Sunshine Act. Okay, so what happens once the meeting is convened? This is where the change takes place. Okay, recently, there was the case of Coleman versus Parkland School District. Prior to this case, we would say here, I would say during training that the board could vote to make a change to the agenda. That is no longer the case. Now, this is based on the ruling of the Pennsylvania Commonwealth Court. It's my understanding that the decision has been appealed to the Pennsylvania Supreme Court. But until the Supreme Court rules otherwise, if they choose to rule, this is where we are, okay? The board cannot make any changes to the agenda unless they are of a de minimis nature. They cannot make any changes to the agenda, particularly if it involves accepting a contract or the expenditure of any funds, okay? And if they choose to modify the agenda, this is what they need to do. First, they need to give a reason why they want to modify the agenda. That needs to be stated in public by the chairperson. Then they need to vote to change the agenda, okay? And that is because the vote will be reflected in the minutes so that there is memorialization of the public record, okay, or in the public record that a vote to change the agenda has taken place. Then at that point, they can deliberate and potentially discuss what it is they've amended the agenda for or with and take a vote on that. They don't have to take a vote, but now it becomes that deliberation. Again, it gets entered into the minutes and it becomes a matter of public record. So the minutes would reflect potentially two votes. First, we're going to amend the agenda. Second, we're going to vote on the actual issue that we amended the agenda with. Okay. And maybe they'll decide, well, we're not even going to vote on it. Okay. You do not have to vote on an agenda item if you don't want to. But if you intend to vote on an addition to the agenda, that's how you would go about doing it. But because of Coleman versus Parkland School District, you can only vote on de minimis. You can only change the agenda for de minimis reasons. Okay. Just so everyone understands that. In the case of Parkland School District, earlier that day, the teachers union, I believe it was the teachers union, ratified a potential contract. So the board thought, well, since we have a ratification vote by the union, let's go ahead and approve the contract tonight. So they amended the agenda and then voted on the contract. No one was aware that they were going to do this. So Coleman filed suit, and the Pennsylvania Commonwealth Court agreed with Coleman. Okay, so that's the the basis for this change. So any amended agenda needs to be posted within 24 hours. So if you do, and I'll see the question coming up here, I'll get to that. Once the agenda has been amended, okay, the amended agenda needs to be posted, okay, and it needs to be posted within 24 hours after the meeting has been concluded. Okay, so then the question comes up, well, how long does it need to be posted? The law does not say. So again, George's logic, 24 hours, there's a 24-hour window prior to the meeting. There's a 24-hour window after the meeting. So I'm going to say it needs to be posted at least 24 hours. Then you can take it down. Again, no basis in law. It's not in the Sunshine Act. I'm simply extending logic here and saying that's what I would do. All right. If you think differently, no problem. Okay. Again, it's going to come down to, is my logic reasonable enough to convince a judge if someone were to file a complaint? Okay. And that's the logic I would use. Okay. But that's where we are. Okay. So the question has come up. So we could discuss, say, a policy change if it is not on the agenda. I would be very careful about that. If the, because that constitutes, a policy change constitutes deliberation. Okay, and if it's of a policy level nature, I would say no, because your agenda must reflect everything you intend to take action on. And if you're discussing a policy change, that discussion constitutes deliberation because it could lead to a vote. The definition doesn't say will lead to a vote. It says could lead to a vote. You don't necessarily have to vote, but if it could result in a vote, that's deliberation. So discussion of a policy change, I think, would satisfy that definition, and I would stay away from that. If you're going to discuss a policy change, that should occur in a public setting, and it should be on the agenda for that meeting because it could have a significant impact on how the law is applied and how it impacts the public that you serve. Okay, so I would be very careful about that. Okay. Public comment. All right, now I should clarify, public comment does not apply to state agencies, the public comment provisions. It's not based on what the law says, it's actually based on what the law doesn't say. And when you look at who public comment applies to, it doesn't include state agencies. Okay, so boroughs, townships, school districts, authorities, and the like still must adhere to the public comment provisions. Commenters can be limited to residents and taxpayers, okay? Someone comes in from out of town, they sign up for public comment, you can say, no, I'm sorry. The law says we don't have to listen to you, so we're not going to allow you to make public comment. The public can comment. They have the right to comment on issues that are or may be before the board prior to any pertinent vote taking place. Now, at issue is the fact that that word may is in there because that opens it up. I mean, the board might have something very important, that they want to vote on tonight, but they have to have public comment prior to the vote. And then some guy stands up and starts complaining about the potholes on his street. And that's nowhere on the agenda to be found. Well, because that word may is in there, he has the right to comment. And you want to be very careful about shutting anyone down during public comment. This happened a couple years ago in the Pennsbury School District, where the board, there were some very hot button issues going on, and heated public comment, and the board was shutting down anyone who wasn't discussing what the board wanted to discuss. Okay, well, they turned around and the people who were shut down filed suit in federal court claiming that their First Amendment rights were being abridged. And sure enough, the federal courts agreed with them. And I found out last month, someone on one of these webinars was kind enough to update me that the matter was settled. I think it was $300,000 settlement that it cost the school district for telling someone, hey, you can't comment on that because it's not germane to what we're talking about. Be very careful, okay? You need to be patient, with people, but let me talk about this in a little more detail in the fact that the board may establish reasonable rules for public comment. Now, typically, we think of time limits, okay? Everyone gets 3 minutes. Well, what if you're talking about some hot button issue tonight that you're going to vote on, and you've got a group that shows up and they all have the same t-shirts on, okay? And they all sign up for public comment, and you're thinking, oh my gosh, we're going to be here all night. We're going to hear the same thing over and over again. The chairperson can approach that group and say, hey, what if you guys appoint a spokesperson and we'll give you 10 minutes for public comment rather than the typical 3 minutes? Okay. Would you be in agreement with that? It might make things go quicker. Everyone would have their say, get their points, on the record and so forth. And if they agree to that, then great, problem solved. It's reasonable to do something like that. Okay. And then there's another practice that many boards have adopted. It's specific versus general comment period. Okay, you've got a hot button issue you're going to vote on tonight. A lot of people showed up. So prior to the vote, you have a specific comment period where you say, we're going to allow public comment, but we want that comment to be only about what it is we're voting on. Okay. And then at the end of the night, you have a general comment period where the guy who wants to complain about potholes, that's his chance to stand up. And at the end of the night, he can, rant about the fact that there's too many potholes on his street. There's nothing in the Sunshine Act that says this is how you do it. Rather, we regard this as a best practice. Okay, there's many townships, many boroughs that are doing this now. It seems to work for them. Okay, so maybe you want to pursue it. Maybe you want to explore it, see whether it might work for you. Again, I just want to say nothing in the law says this is how you do it. Okay, and we talk about reasonable rules. Well, many boards have adopted like Robert's Rules of Order or procedural rules that they vote on. This is how our meetings will be conducted. Most of those tenets, Robert's Rules of Order, they have provisions within those rules that allow setting the rules aside. So the board takes a quick vote. We're going to set the rules aside to accommodate, reasonable action that we can take to allow for public comment. All right, you can do that. Okay, there's nothing preventing you from, diverting from your rules given the circumstances, as long as you adhere to the spirit of the Sunshine Act and allowing everyone their right to public comment. Okay. Now, executive sessions. A board can gather outside of the public eye to discuss sensitive, non-public issues, but it must adhere to certain provisions within the Sunshine Act for that to be legal. When they gather like this, it's called an executive session. They can be held before a public meeting, actually during, in the middle of a public meeting, or after that public meeting has concluded and announced for some future time. When you're announcing that either you've had an executive session or you're going into executive session, you must provide the complete reason. Okay, and this goes back to what I was describing when it comes to agenda items. The legal citation is the Reading City Council versus the Reading Eagle. Reading Eagle is the local newspaper in Berks County. And what was happening was that when they were getting ready to go into executive session, the chairperson would stand up and say something to the effect, we're going into executive session for personnel reasons. The Reading Eagle disagreed. They said that's not enough. They took it to court. It went up to the Pennsylvania Commonwealth Court. Commonwealth Court agreed with the Reading Eagle. They said, you've got to tell people more. And then they went into a discussion. And essentially, what they said was, you've got to give enough of a reason so that the public can trust you're going into executive session for the right reasons. I'm paraphrasing a lot, okay? I'm reducing several paragraphs of legal discussion down to a soundbite. But basically, the court is saying, look, when you go into executive session, you're meeting in secret, okay? And you've got to give the public enough of an explanation that you're meeting in secret for the right reasons. So rather than just saying personnel reasons, you would say something to the effect that we have an issue with one of our employees with an alleged violation of a work rule. We're going into executive session to determine whether or not this employee should be suspended without pay. Okay, and then that leads to the secretive meeting. Okay, now as a member of the public, that's enough for me to realize, okay, this isn't something that you can discuss in public, okay, because that employee has a right not to be embarrassed, you know, and so forth. Or we're meeting with our solicitor to discuss a lawsuit that's been filed against the school district. Okay, and then that lawsuit, here's the case citation. Okay, well, you know, legal strategy, that makes sense that you would not discuss that in public. Okay, so I'm satisfied. All right, so you give enough of a reason. You don't just say legal reasons. You don't just say personnel reasons. Rather, you give that expanded explanation. Now, for executive sessions, there's no requirement that you keep minutes. And if you do keep minutes of your executive session, there's a provision within the right to know law that exempts those minutes from public disclosure. Okay, they're not public records. No official action can be taken during an executive session. Okay, official action is a vote. All votes must occur in a public meeting. So let's go back to my example. Okay, we hear the various sides of the work rule infringement, and we decide, or infraction, and we decide that yes, we're going to suspend this employee for 3 work days. Okay, now I can poll all the members of the board informally. Well, you know, Fred, what do you think? You know, how do you intend to vote on this? Mary, what's your impressions? Okay, all right. So that's what we're going to do. Okay, so you conclude the executive session, then you come out into the public meeting, and that's where you must take the vote. Okay, the vote, the actual vote. So it's a matter of public record. You know, all in favor of suspending John Doe for 3 work days, you know, signify by raising your hand. Okay, motion carries. Okay, that all gets recorded in the minutes, so it becomes a matter of public record now. If you fail to do that, then any action that occurs is not based on an official action, okay? And it could be contested in court, okay? So you need to be careful about making sure that any decision on a subsequent course of action that's decided during executive session is memorialized by an official vote that must occur in a public setting. Okay, just so everyone understands how that works. Now, the reasons for executive session, well, we talked about personnel matters such as hiring, firing, discipline. Personnel policy issues are not an appropriate subject for executive session. That must occur in public session. Okay, so if you're talking about like leave policies or hiring policies, no executive session. If you're talking about hiring for a specific position or a specific person, yes, you can talk about that in executive session, but policy issues, no. Discussing labor negotiations, you can do that in executive session. Purchasing, leasing, or selling property. Now, the law only says purchasing or leasing, but there is a Commonwealth Court decision that includes selling. So if you're looking at selling off a parcel of land, you can discuss that in executive session. Consulting with counsel about litigation, that makes sense. Avoiding violating privilege or confidentiality. Okay, privilege is sensitive discussions between your board and your solicitor. Okay, that's covered by privilege. You can do that in executive session. Discussing university admission standards. I wasn't around in 1950 when they put that in there, so I don't know. Discussing emergency preparedness, like homeland security issues, emergency evacuation plans, and the like. Okay, you can discuss that in executive sessions. Okay. Okay, I've been talking about the straight face test violations. What happens? Okay, well, first offhand, you need to know that the public, during a public meeting, can object to any perceived violation at any time during the meeting. They can stand up, respectfully address the board. I think that what you're doing here is in violation of the Sunshine Act, and you need to address this. And then they sit down. Now, the board, what if they agree? What if they think, you're right, we forgot to vote on this. Okay, let's go back and vote on it now. The board can cure a perceived violation. It's kind of like no harm, no foul. Okay, you can go back and correct it. It could be at a subsequent meeting where you can stand up, the chairperson can stand up and say, at the last meeting, procedurally, we forgot to do this, and that resulted in a Sunshine Act violation. We're going to go back and correct it now. We forgot to allow public comment, and it just happened so fast. We're going to allow public comment now, and then we're going to vote again on the issue. Okay, you're curing that previous violation. Okay, so you can do that. The law allows the ability to cure. But what if the board disagrees with the person? Okay, and so they say, no, this isn't a violation. We're on sound legal grounds here. The person has 30 days in which they can file a complaint. If it's a local agency, borough, township, school district, or whatever, they would go to their county court of common pleas and seek the appropriate legal relief that they're seeking. Okay, I want an injunction. I want sanctions or whatever. Okay, and usually what happens is, it gets assigned to a judge, and the judge then would have a hearing, and that's where that straight face test takes place. The parties address the judge. We think this is a violation. We don't think it's a violation, and here's the reason why. And the judge then decides. Okay, if the judge agrees with the complainant, they have a lot of leeway in the sanctions that they could mete out. They could simply acknowledge that, yes, this is a violation, don't do it again, slap on the wrist. Or they could void the vote. They say, you have to, have a do-over. They could void the entire meeting if they think it's appropriate. And if it's particularly egregious, they could level financial sanctions. Under the law, a financial sanction for the first offense could be up to $1,000. And the $1,000 cannot be paid by the agency. It must be paid by the public official. coming out of their pocket and they can't get reimbursed, okay, that's where it gets painful, okay? And then it's $2,000 for the next violation. But that's why I think it's so important that we need to address that straight face test, okay? Because it can get really painful if you play fast and loose with the Sunshine Act. The other thing that I want to mention is that if there is suspicion of criminal intent, you can also go to the county district attorney. But the district attorney can only investigate and rule on the criminal aspects, not the Sunshine Act violation. The judge must do that. The other thing that, and we've seen more activity in the last couple of years with the Sunshine Act and filings. One of the things that judges are doing is they say, yes, this is a violation of the Sunshine Act, and I'm going to require that the council people get Sunshine Act training. So they've been referred to the Office of Open Records to get the training, and we've conducted that training. And then we provide a letter to the judge saying that, you know, XYZ council members and the mayor have gone through our Sunshine Act training, okay? And then the judge's decision is then satisfied, okay? So that's happened a couple times. So judges, you know, they have a lot of leeway and they're using their imagination on, you know, how to deal with specific violations and the like. We have seen the financial sanctions, but it doesn't occur a lot. You know, I don't want you to get really worried about that. Usually when there's a violation, it's an honest mistake, okay? And the judge just says, okay, go back and do it right. We've had a couple instances where, you know, there was one several years ago that I remember out of Lancaster County where I think it was a school board president was actually recorded saying, and we're doing this to avoid the Sunshine Act. Well, yeah, that didn't go well for that guy. So, you know, be careful, but don't be overly, well, you want to be as careful as you can, but don't get really wigged out over the idea of financial sanctions if you make an honest mistake. Okay, you're allowed to go back and cure it. And that could very well happen before the complaint is ever filed or before a hearing is ever held. Okay, so the Sunshine Act allows you a great deal of flexibility and discretion, and just as long as whatever you do is within the spirit of the act. And we go back to that preamble that we were talking about. Okay, as we're drawing to a close here, I do want to discuss some miscellaneous provisions. And first offhand, meeting minutes of all public meetings need to be recorded, and they would record the board attendance and how they voted. If there's a roll call vote, how each member voted, okay? And it becomes a matter of public record. And I'll just, you know, this is a different topic, but for those of you who are curious about the nexus between the Right to Know law and the Sunshine Act, the minutes of public meetings as required by the Sunshine Act are considered public records under the Right to Know law, clearly public records. And why someone needs to file a Right to Know request to see meeting minutes is beyond me. But, you know, like I said, that's a different topic for another day. Now, the question came up about recording public meetings. Yes, okay. The public has a right to record any public meeting, and they do not have to announce that they are doing so. It is not a violation of the Sunshine Act, and it is not a violation of the wiretap law. So I can take out my cell phone, set it to record, put it in my pocket, walk into the public meeting, and there is no expectation of privacy in a public meeting. Usually, what I recommend is that the chairperson, when they're doing their introductory comments, they would include, and by the way, this meeting very well may be recorded by anyone in attendance. And if by chance the board is recording, let's say for purposes of keeping minutes, that recording is in fact a public record until such time as it's destroyed. Okay, so I can file a right to know request for a recording that the borough's school district or, township or city or whatever is making of the meeting itself. Okay, questions come up. Do minutes have to note where attendees are joining from, in person or by phone? I don't think they need to do that because many of the codes that were written, you can also find provisions about minutes within the codes, the borough code, township codes, and the like. They were written before the advent of online technology. So usually they don't mention anything about someone joining virtually. But I wouldn't hesitate to put that in there, that, so-and-so logged in remotely. Just so it is a matter of public record that that's how they joined. Nothing in the law that says you have to do that, nothing in the law preventing you from doing it. I just think it would probably be a good idea. Okay. And like I said, I'm not providing legal advice. So take it for what it's worth. Okay, so back to recordings. Yeah, you can record public meetings to answer the previous question. And then any agency recording are public records. Okay, so we've made it to the end here. A couple good questions coming through. I'm, glad we had so many people attending, especially since some of you were probably seated at your first public meetings last night. It's good to know what's expected of you when it comes to public transparency. So kudos to you for being part of our session here this morning. If you have any more questions, now's the time to get them in. But while you're thinking of those questions, I just want to draw your attention to our website, okay? If you've never sat in on one of these webinars, you're going to hear it for the first time. If you have, you know what I'm about to say. This is the best government website you will ever see, okay? On this website, you're going to find guides for citizens, guides for public officials, guides for agencies about the Right to Know law, about the Sunshine Act, FYI pages. If you're interested in how the Office of Open Records has ruled on cases, you're going to find searchable databases with all our cases in it, 30,000 and counting, okay? Any pertinent court decisions, okay? This website is updated 6 days a week with new decisions, informations about training opportunities. If you're a true geek about government transparency, you can sign up for our Twitter feed, where every morning at 7 a.m. we will wake you up with all the news of the day relative to government transparency, okay? If you have questions, okay, as I indicated earlier, you can send us an email, you can phone in, and we have staff waiting for your phone calls, okay? But honestly, we will get you steered in the right direction as best we can. So feel free to reach out to us and we'll help you, okay? Because this is important stuff, especially if you're a public official. Okay, question has popped up. We can't wait to advertise the monthly meeting schedule until after the reorg meeting, since that will be voted on at that meeting. No, and usually I cover it for whatever reason. I didn't mention this particular scenario today. Okay, your initial advertisement must include the dates for the regular meetings that you anticipate having for the rest of the year. So you have your organizational meeting and it's decided, well, we can't meet the first Tuesdays because we have a conflict. So we're going to change it to the second Tuesday. All right, makes sense. So you vote to change the meeting schedule. Well, because you've changed it, you now must have a second advertisement that is published at least 72 hours before the next meeting. Okay. It doesn't happen a lot, but it's not unusual. Okay. So what you're saying, Tina, it does happen, and that's how you would deal with it. You would have a second posting. Okay. Does it have to specifically list the dates, or can it say the first Monday of every month? Yeah, that's a great question. I would play it safe and list the dates. If it's the first Monday, have the secretary sit down with a calendar and figure out the date of the first Monday just to play it safe. Because I think, I'd have to pull up the law, but I think it does specifically say the date. Okay, so I would just play it safe and list the date. Okay, good question, and it has come up before, and yeah, that's how I would deal with it. No case law that deals with it specifically, but common sense applies, and I would just play it safe in that scenario. Okay, any other questions, folks? I'm going to sign off now, but I want to again thank you for your participation. We'll be back here in 2 weeks with another webinar, and hope to see you there. If you're in the line of the storm that they're predicting for this weekend, hey, take it safe, don't overdo it, and hope to hear from you soon. Okay, signing off now. Take care.